Is the tide turning against Israel in the United States? Welcome to Connections, the Arab Studies Institute's interview program. I'm Mouin Rabbani, and for this episode, we're delighted to be speaking with Diala Shamas. Diala Shamas is a senior staff attorney at the Center for Constitutional Rights, CCR, in the United States, where she works on challenging government and law enforcement abuses perpetrated under the guise of national security, both here and abroad, both in the United States and abroad, rather. Diala Shamas, it's a real pleasure to welcome you to Connections.
Thanks so much for having me, Wayne.
I'd like to start by asking you about the recent Supreme Court case, which grew out of a lawsuit filed by the Jewish National Fund against the U.S. Campaign for Palestinian Rights, accusing it of material support to terrorism. How did this case end up in the Supreme Court in the first place? What did the court decide? And I'd also like to ask you two other questions. I'm just throwing them all out now, but we'll get to them. Given the absurdity of the allegations, why is the Supreme Court ruling in any way significant? And finally, I'd also be interested to hear about your personal involvement in that case.
Absolutely. Well, to start at the end, I'm one of the attorneys representing the U.S. Campaign for Palestinian Rights in the lawsuit that was filed against them in 2019. So it's quite a long journey to get to the ultimate denial of certiorari that happened by the Supreme Court early last week. So it was January 22nd.
Mhm.
And so just to sort of trace a little bit that long trajectory and what happened over the course of those last few years. In November of 2019, the Jewish National Fund, the Israeli Jewish National Fund, so Keren Kayemet LeIsrael,
Which is a parastatal organization, if I understand correctly.
essentially it has a special status under Israeli law, and uh, along with a group of individual Israeli plaintiffs who are dual nationals, so also US citizens who live in the so-called Gaza envelope, brought this case alleging that the US campaign is liable for material support to terrorism as well as other torts. And the main acts that they cite to in their really extensive complaint are first that the US campaign was a fiscal sponsor to the Boycott National Committee, the BNC, and the complaint also cites to certain tweets and emails sent to supporters that the US campaign put out there, all that were critical of Israeli military's targeting of civilians and unarmed protesters during the Great Return March of 2018 and 19, which you might
18.
remember.
Yeah.
And the last thing is the U.S. campaign's participation in a alleged participation in a campaign called the Stop the JNF campaign. And so that was the basis of a tort claim the JNF was
So
bringing.
they weren't accusing the U.S. Campaign for Palestinian Rights of either engaging in any violent act or of providing or of participation in any violent act in any way, but rather because they were supporting or had issued an expression of support for the Great March of Return, where there was massive violence because several hundred Palestinians were killed and many others wounded by Israeli snipers, that they were claiming was an act of material support to terrorism.
Correct. There were no allegations of direct involvement in any kind of violence. On the contrary, the plaintiffs were trying to sort of push the law well beyond its permissible scope. And it is already a very broad law.
You're
That
talking about U.S. anti-terrorism legislation now.
Correct. So we call it material support to terrorism, MST in the business. And essentially what they're saying is through a series of, multiple degrees of attenuation and separation, and I'll try to retrace the sort of elaborate series
Please
here,
do.
but essentially it's really hard to say it, both to kind of understand what it is that they're actually alleging, I think sort of deliberately confusing complaint, but also difficult to say with a straight face, to be frank, that the US campaign, by virtue of fiscally sponsoring the Boycott National Committee, which in itself is a coalition, which includes a coalition, one member of which is a terrorist organization. In this case, it was Hamas, that they were
A
mostly
designated terrorist organization by U.S. law.
United States, correct, designated by the United States as a terrorist organization. And therefore, anything that Hamas allegedly did or was responsible for would be attributable to the US campaign under their theory.
So
And
it's
the
kind of
act,
my cousin has a friend who has a cousin who has a nephew situation.
that's essentially what the complaint reads as. And to the acts, the alleged acts of terror that the plaintiffs, or rather the harm that the plaintiffs are in that case kind of alleging, are um, largely mental harm as a result of
Ouch.
seeing the kites and the balloons, the incendiary kites and balloons that were launched by marchers during the Great Return March from Gaza into Israel. And for the Jewish National Fund, it's the burning of trees that are on the Gaza envelope. So
So if I can just interrupt to clarify, because the Jewish National Fund administers the vast majority of land within the state of Israel on behalf of the state. And as the fund's name implies, it administers these lands for the sole and exclusive use of Israel's Jewish citizens and foreign Jews rather than the citizens of the state of Israel, including its non-Jewish citizens.
well, as many in the public have pointed out, it is ironic that an organization that is self-accused of participating in what be war crimes and unlawful appropriation of property and certainly discriminatory behavior is the one that is claiming victimhood in this scenario and really wielding U.S. counterterrorism laws to silence criticism of Israel. And remember that the main tort, and so just to be clear, the JNF itself as a plaintiff, its main claim was not even the material support to terrorism claim. It was this tort claim against the U.S. campaign for participation in something called the Stop the JNF campaign, which is a campaign that was raising awareness about the JNF's role in what you were describing. And so that claim was dropped at the district court level and didn't go up on appeal. But it was clear that the JNF, as a quasi-state agency, was sort of really lead plaintiff. The plaintiff's attorneys were regularly referring to them as the main plaintiffs, as the main clients, and didn't even drop them from the appeals, even when their claim was no longer technically on.
And can I ask where this lawsuit was initially filed in the United States?
In federal court in Washington, D.C.
I see. And so that court dismissed the case.
So that
And
court dismissed the case, and then they sought an appeal, and we had a argument at a hearing for three judges. They dismissed the case. They affirmed.
can I ask on if it's not too complicated, on what basis did the federal court dismiss the case? Did they say there's too many degrees of separation? Did they say that the accusations are meritless, to use a word that's been used frequently recently and referred to in reference to a different case?
Yes, I mean, it essentially, we filed a motion to dismiss. And so the court found that they didn't have any plausible claims. I'll try to pull up the actual quote, but it essentially that there's nothing to see here, and it doesn't meet the threshold to make it past the motion to dismiss.
Right.
So there's nothing plausible in here. in the kind of connections that they were alleging between the U.S. campaign and any and the acts that allegedly injured the plaintiffs.
So the lawsuit failed, the appeal failed as well, and then they appealed the appeal, so to speak, by going to the Supreme Court. And the Supreme Court wasn't required to hear this case, but chose to do so. Do you have an indication of why it did so?
Well, the Supreme Court didn't hear the case. The Supreme Court, when you go to the Supreme Court, it's a process where you the petitioner, in this case it was the JNF, seeks certiorari, and oftentimes they just dismiss it or they just decline to grant that. In this case, the Supreme Court ordered us to brief it, and not only, and they did at the Supreme Court level, the plaintiffs did at the Supreme Court level what they have been doing from the outset, which is at every turn and every opportunity, filing, additional briefing, completely meritless, baseless, not based in any kind of law. So at the Supreme Court level, they filed a couple of supplemental letters, and there were also several amici, which are friends of the court briefs that came in, urging the court to take this case on. The names of those amici were all names that are recognizable to many in the legal community and probably the broader activism community
Can
who
I
are
guess
familiar.
Alan Dershowitz?
Not Alan Dershowitz, but a few other organizations that have been involved in lawfare against Palestinian rights and efforts to sort of suppress the broader movement. And they were all making the same kinds of arguments, urging a very expansive interpretation of material support to terrorism laws, well beyond what is permissible. And the plaintiffs at the Supreme Court level filed, saying that October 7th changes everything and called it the elephant in the room, and, tried to bring in all sorts of irrelevant facts to the U.S. campaign's behavior, which is ultimately what the question before the court would have to be. And so ultimately the court denied cert, so we didn't have a hearing, thankfully. And I will say, though, it was a very long road. It required multiple filings, lots of lawyer hours. This should have ended. This should have never started in the first place, but it should have also just ended at that first district court hearing.
And that takes me to my next question. The JNF failed at every juncture of the process, so to speak. I presume they had competent lawyers who will have advised them from the outset that this case is going nowhere, yet they chose to proceed. So clearly, this was a case of premeditated legal harassment, if you will. Do you see the purpose of it to seek to bankrupt those they are accusing because of the time and resources and funds required to defend themselves? Is it more a case of legal intimidation in order to get these people to conclude that defending Palestinian rights is simply not worth it, given the financial and reputational and other costs involved? What do you think lay behind a lawsuit that those who bought it must have known from the very outset wasn't going to achieve anything?
I think it was a very transparent effort at silencing the U.S. campaign for specifically actually targeting the boycott movement. So much of the allegations were centered around the Boycott National Committee that felt like it was really the kind of advocacy target here of the plaintiffs. And we, of course, know that at the time the lawsuit was filed, and still the Israeli Ministry of Strategic Affairs really had the boycott movement in its crosshairs. And so this was, I think, a test case to make radioactive the boycott movement. If you can smear that movement with some kind of allegation of association with terrorism, then it's making everybody much less likely to want to engage with them, and you effectively undermine that movement, right? all of this is a sort of attack on relationships and social fabric and political networks
Right.
and associations. So I think, and that was something that we said plainly to the court at the hearing. This was an effort to silence and punish the US campaign for its support for Palestinian rights. And I think the court heard that.
Yeah.
And so,
But
yeah,
given these motivations, do you think the JNF succeeded, even though it lost
absolutely
its?
not.
Yeah.
Absolutely not. I mean, given those motivations and given that they threw everything that they had at this case, not only with all the appeals, but efforts to get rehearings and efforts to get judges withdrawn, and they did all sorts of things in the interim too, and they failed. And
Yeah.
that is a really significant win, one that the movement should be celebrating, one that we should keep in mind every time we see allegations of affiliation with terrorism thrown around. They threw everything that they had at this case.
Yes, and they did lose in court, and legally it was a massive defeat for them. But in terms of these broader motivations of silencing people and getting people to conclude that it's not worth taking up the cause of Palestinian rights, or having the JNF and similar organizations as your adversary, did they also fail in that?
I think Exhibit A would be what we're seeing now.
Mhm.
Certainly, the US campaign is being incredibly active in its response to what is happening in Gaza, the unfolding genocide that we're seeing. I think the intended chilling effect that lawsuits like this had uh, are simply not playing out. Now, it doesn't mean that there isn't a cost. It doesn't mean that we haven't wasted resources that should have been put elsewhere to do maybe more affirmative legal work, that it wasn't also a distraction. But ultimately, it hasn't resulted in the chill that a lot of these efforts of association and affiliation with terrorism are intended to get.
And at any stage, did the JNF reach out to either your organization or the US campaign to propose a settlement as an exchange for dropping their lawsuit?
Uh, no,
Okay. I thought maybe at some point,
their attorneys.
they would have
No, their attorneys
together.
never.
Yeah.
Yeah.
So this, as you've mentioned, this falls into the broader campaign by organizations like the JNF, which I think is not often involved in these. Most often, it's organizations like the Defamation League and other organizations that seek to silence Palestinian advocacy in the United States, as you just mentioned. So, in more general terms, how has this worked? Has it focused very much on lawsuits, or is it primarily through legislation, or is it defamation campaigns, perhaps a combination of the above? Are there any particularly noteworthy cases in the silencing campaign that you think we should be aware of?
It's really anything that sticks approach, spaghetti against the wall, and organizations like Palestine Legal, who I'm sure a lot of the folks in your audience have heard of, have been for years pushing back on multiple avenues um, against these efforts to silence Palestinian advocacy in the United States, and that has taken multiple forms. We've, of course, seen anti-boycott legislation in many states, and we've also seen pushes at the federal level. We've also seen other lawsuits, not just raising material support to terrorism allegations, but also a lot of them have been around procedural types of issues. My colleague, Maria LaHood, has been doing this work for so long, for almost 2 decades, defending the Palestine movement. And one notable case is the Olympia Food Co-op that was subject to endless litigation for a
This is
resolution that
in
they
Washington State.
in Washington State.
Mhm.
a resolution that they took, a boycott resolution, and it was procedural litigation, but one that certainly bogged them down and to teach them a lesson.
This was several years ago, I believe.
It was. I'm not too familiar with the specifics of the timeline, but we ultimately won it. But it took many years
Mm-hmm.
to put that one to rest.
To
We also,
basically have a court confirm its right to boycott.
well, it was a procedural
Mm-hmm.
object. It was more like you didn't boycott in the right way, or you didn't reach
I
this
see.
vote in the appropriate way. It wasn't even touching on the core of the right to boycott. And that's what a lot of these things, if you think of campuses, much of what's happening is you didn't file the right paperwork, or you didn't go through the right protocol, hire the appropriate security. It's not,
Yeah.
core um,
You're
getting
now
justice.
talking about technical pretexts, if you will, that those who are seeking to silence Palestinian advocacy use.
Yeah, yeah. So we're really seeing a range. But I think it's worth pausing and talking about the allegations of terrorism, because, of course, we're in a moment where they're really coming to the fore. I mean, they've been around for a very long time. And actually, the Center for Constitutional Rights, along with Palestine Legal, have been working with Professor Darrell Lee to really look into the origins of a lot of the U.S. counterterrorism laws and place, as we have known, but now we've sort of done the research and data to back this claim up, that Palestine efforts to silence the movement for Palestinian rights and liberation have always been at the core of the development of U.S. terrorism law. First time that the word terrorist was referenced in U.S. federal law is in relation to Palestinians.
Mhm.
We see that happen in other contexts too. So the U.S. campaign case should be placed in that long history. Of course, a lot of people are familiar with efforts to criminalize charitable giving to Palestine that had been pushed before, the attacks of September 11th, and then really gained a lot of traction afterward.
This
And
is the
cases
Holy
like
Land Fund
Land 5,
case.
exactly,
Mhm.
exactly. So that is the legacy that that the core difference here is those were criminal cases,
Mhm.
and then now we're moving into um, private actors, private litigants seeking to enforce these sort of civil versions of, the material support to terrorism laws, to put it in a sort of
Right.
succinct layperson term. Of course, there were also civil suits there. The Mouin case, which was brought by the same lawyers as the U.S. campaign case,
Mhm.
is a case where they also went to they sued the Holy Land Foundation. So this is a part of this very long history of using U.S. terrorism laws, which are overbroad and raise serious First Amendment concerns, and we've been sort of pushing back against for a very long time. And then we're seeing this kind of almost full circle moment, you know, as those laws have expanded significantly post 9/11 and other moments, they've also gone well beyond the Palestine movement, well beyond the Muslim kind of Muslim population as like a core primary target of their expansion. And we see various forms of anti-protest laws and counterterrorism laws being deployed against other movements like the Black Lives Matter movement, environmental justice movements. And now, of course, we're really seeing them be a topic of headlines after October 7th.
And so Palestinian advocacy is, in a sense, the canary in the coal mine, that those who have a more general authoritarian agenda seeking to suppress progressive movements or protest see in Palestinian advocacy a target of opportunity that's easier to establish legal precedents against and then move on to these other movements that you've mentioned. And my other question is, because you do also work outside the United States, if you're familiar with similar initiatives in, for example, Western Europe, that other bastion of free speech and liberty, and whether how you would compare the situation in these two regions.
Mhm. Yeah, I mean, I'm not as familiar with the intricacies of the European context, but certainly we are in regular touch with partners there who are doing very similar movement defense, lawyering, supporting activists who are facing a whole range of efforts to silence them, legislation, law enforcement scrutiny, shutting down of events, you name it. So one group that has been doing an incredible job at just pushing back against this tide repression is ELSC, the European
Yes, based in the
Legal,
Netherlands. Yeah,
based
European
in the
legal
Netherlands.
support. Yeah, yeah.
Yes, really fantastic work. Have been also documenting the repression in Europe, and I think that the the force of anti-Semitism accusations is far more kind of significant in Europe, and I think we're seeing, of course, we see those accusations being lobbed very um, aggressively and intentionally against criticism of Israel here in the US, but I do think that it takes on a whole other dimension
They seem
in
to
the
have
European.
more resonance. Yes. Mm.
Yeah.
I'd now like to turn to another more recent case, which is very different, because in this case, your organization, the Center for Constitutional Rights, is the one that's bringing a lawsuit rather than defending against it. And that is the lawsuit that was recently filed by CCR, I think on behalf of a number of Palestinian Americans with family connections in the Gaza Strip, if I'm not mistaken.
Yeah.
This was a case filed in California against US President Biden, the Secretary of State Antony Blinken, and the Secretary of Defense Lloyd Austin, perhaps others, you'll correct me if I'm wrong, accusing them of complicity in genocide or seeking to prevent them from taking certain measures in support of Israel's genocidal onslaught on the Gaza Strip.
Yeah, absolutely. Last week was a really big week. We filed this case, Center for Constitutional Rights, in November.
Mhm.
And those are the defendants, so Biden, Blinken, and Austin. And the plaintiffs are, in addition to individual Americans with families in Gaza, we also have three individuals who are in Gaza who
Mhm.
have been displaced and injured and who have lost so much.
Are those also US citizens?
No, they're not.
Mhm.
They're Gazan,
So this is
Palestinian.
applying principle of universal jurisdiction then?
Yeah, under the U.S., it's the Alien Tort Statute,
Mhm.
which allows them to come into court with these international law claims. And
Mhm.
then we also have two organizational plaintiffs, Al-Haq, as well as Defense for Children International Palestine, on behalf
These
of
are
their
two
working group.
Palestinian human rights organizations based in Palestine.
Correct, who also have staff in Gaza and whose work has been completely transformed and upended, and who've also suffered, significant harms and are bringing this case.
Mhm.
We had a hearing on Friday. So we filed something called a motion for preliminary injunction. If your listeners are familiar with the posture of the ICJ, in many ways it mirrors it here, because what we're telling the court is the harms to the plaintiffs are so severe and the situation is so urgent that we cannot afford to wait for the normal course of the litigation to unfold. It'll be basically too late.
Mhm.
And so the court, we request these a preliminary injunction, so an order ASAP as soon as the court can. And we're requesting that the court order the defendants to stop the significant substantial support to that is enabling Israel's assault on the civilian population in Gaza.
And given that U.S. courts, if I'm not mistaken, are generally hesitant to get involved in matters of foreign policy and kind of view this as a prerogative of the White House. Does that um, suggest that this is a suit that has little chance of moving forward?
We don't think so. We think that so that was certainly the government's central argument at the hearing.
That the
Um,
court has no standing.
yes, that this is a matter of foreign policy and that the
Yeah.
courts shouldn't be meddling into, the executive's authority here. But a lot of the cases that have developed that doctrine, which is called the
Mhm.
political question doctrine in US law, are really distinguishable from the stark facts here. And as our lawyers argued in court on Friday, really compellingly, there are very clear questions of law here. This is exactly the sorts of legal questions that courts are best suited to answer and can
Right.
answer and can issue the sorts of relief that we're seeking.
And do you have
Certainly when you
sorry,
know,
please go ahead.
especially when you measure it up against the really significant harm that we have put forward in a complaint, but that our plaintiffs, who were many of whom were in court, which is another really remarkable moment if you think about the history of U.S. federal courts. They testified as witnesses in court about what their families have been going through. We even had a Dr. Ahmadinejad, one of the plaintiffs, call in from Gaza on the hospital floor, where he was miraculously able to get a connection. And so I think the judge um, certainly heard that. He made a comment at the end of the hearing that this is the most factually difficult case he has ever dealt with in his career, and he's a senior judge. And he described the testimony as gut wrenching, and we're hoping that he will, find ways to issue the relief that we're.
And is there a timeline for this? Do you have an indication of when you expect to hear back from the
It could
court?
happen at any moment because of the faster paced posture here.
Mhm.
So it could be a week, 2 weeks, 3 weeks.
Mhm.
It's sort of impossible to
Yeah.
to to know.
And if you do succeed, are we then in a situation where just as Secretary of State Blinken used some uh, powers that he apparently has to send all manner of high explosives to Israel to continue with its genocidal assault without any congressional oversight or approval. Do you know, would the government have similar powers to ignore any court ruling?
Well, then they would be in defiance of a judicial order, and that would be a really serious,
Yeah.
um, you know, a really serious concern that, I think the more likely outcome is that they would challenge it, challenge the court order.
And if you do succeed and the government decides to appeal that ruling, are they under requirement to adapt their policy pending the conclusion of their appeal, or can they continue with their current policy until an appeal is concluded? Do you know?
I think those are the kinds of questions that we would be uh, fighting vigorously over.
Mhm.
And I think the the bigger thing here is, at that point, you'll have an ICJ rule that carries a lot of weight and
Which
requires.
you didn't have when you first filed this lawsuit in November.
No, the decision came in hours before our hearing started, so we were
Oh,
able
that's
to
convenient. Yeah.
give the court notice of it, and of course, we're all still digesting its contents. But
Yes.
fundamentally, it was an affirmation that there's sort of that this plausible case that a genocide is unfolding, and the duty to prevent certainly has
Mhm.
kicked in, which
Because the
requires.
U.S. is also a party to the Genocide Convention.
Correct. Yeah.
Mm.
and and third states, I mean, there's complicity, but even if you don't rise to the level of complicity, you have a duty to prevent, and that certainly
Yes.
includes not sending the very same bombs that are being dropped on
Yeah.
civilian populations.
Yeah.
So we would have that, we would have a court order, and of course, really significant political pressure And I think the hope is that amongst all of these efforts, something will give, and we can sort of stem this massive and ongoing and worsening in many ways assault.
Well, I was listening earlier today to the current session of the UN Security Council and was listening to the US ambassador, the US permanent representative to the UN, and her British sidekick. And they were basically giving an interpretation of the ICJ ruling that sounded like the exact opposite of what the ICJ had actually ruled. They seemed to be suggesting that the court had endorsed Israel's military operations in the Gaza Strip, and that US and UK policies towards this genocide were therefore consistent with the ICJ ruling. So it'll be very interesting to hear now how, should it come to a further court hearing, the Biden administration will seek to spin this in its favor. But so, if I understand you correctly, we should expect to hear at least the initial ruling from the judge in California any day now, and most likely within a few weeks at the most.
That's our hope, yes.
Yeah. And then my final question to you. We've spoken about a number of cases, one which very clearly went your way, another on which we're still awaiting further word. But then, as you mentioned, there have also the reason that these things are now being litigated in court is because a campaign to silence Palestinian advocacy within the United States has, over the years, proven enormously effective and successful. Um, Against that background, is the tide, in your view, finally turning, or has the campaign to silence Palestinian advocacy become so deeply entrenched that it can no longer be reversed?
I think with everything, it's a push and pull. I would argue that it's not been successful. And I think what we're seeing today is a perfect example of it. Yes, there are really high stakes. Yes, people have lost jobs for tweets that they've made, that they've posted.
I mean, you could
Yes,
start a whole media empire just with journalists who've been fired in the past year for expressing the view that Palestinians are entitled to basic rights.
I think that's right. But I also think that if you think of this, if you take a little bit of a historic lens,
Mhm.
um, and I'm not a historian, but I do think that we are seeing the breaking of a lot of the things that were thought to be unbreakable previously. Things that were unsayable previously are now being said. I mean, just thinking of our hearing on Friday, the Nakba was described in open court in detail from a Palestinian perspective by almost every one of our witnesses. And that was because it was a necessity in order to explain to the judge, whether it was how their families got to the US because they were dispersed and we are a fragmented people, or whether it was to explain to the judge the impact of uh, Israeli calls for Nakba now, right? We have more people learning about the political history of Palestinian political organizations, including Hamas, than they've ever thought to care about before.
Mhm.
We have people who are suddenly interested and concerned and moved that were not, attuned to the Palestinian issue before. I think there are also moments where, whether you want to call it empire or power overreaches, oversteps, makes arguments that suddenly no longer make any sense to the lay observer, let alone the people who've been the subject of it for so long. And I think we're in one of those moments. I think the kinds of things that we're hearing the Israeli government say, that the Israeli military is putting out, that Israel's defenders in the US are having to rely on, are just not making sense to people anymore. And whether the outcome is victories in court because, judges or juries are suddenly not buying it anymore, or whether it's because the political tides are turning and eventually people will vote differently and parties will have to respond differently. I do think that the silencing hasn't worked. I mean, there's lots of casualties along the way. People have had a really hard time. I don't want to underestimate the significance of the harm that's also been done. But if you zoom out and look at the overall trajectory, anyone that's been doing this for a long time says this is also a moment of potential.
Yeah. On that hopeful and optimistic note, Diala Shamas, thank you very much for sharing your insights and expertise with Connections. It's been a fascinating conversation. Thank you very much.
Thanks so much for having me.